Hello, my name is Craig Leen, former OFCCP Director, Advisory Board Member for Eightfold. I'm also a partner at K&L Gates in DC, and I'm really happy to be here with you today to talk about an agency that I love and that I was the head of for a little over 2 years, OFCCP, the Office of Federal Contract Compliance Programs. And I'm looking forward to talking to you today about what OFCCP is, what it does, and things that you should know about it as a federal contractor or subcontractor, or as a company that wants to be a federal contractor or subcontractor. In today's class, we're going to start with an introduction to what OFCCP is and its history. We're then going to talk about the affirmative obligations, also known as affirmative action, that federal contractors are required to do and what those obligations are. Following that, we're going to talk about the non-discrimination obligations, which also are obligations that federal contractors must follow. And we're going to, I'll go over those for you. And then I'm going to talk a little bit about diversity, equity, and inclusion ideas that can be incorporated into an OFCCP compliance program so that you can be following all the best practices in this field. And then finally, I'm going to talk a little bit about artificial intelligence and how it can be used to help companies comply with OFCCP obligations. Really looking forward to this today. I hope you enjoy it. So first, just a brief history of the Office of Federal Contract Compliance Programs at the U.S. Department of Labor, or OFCCP, as it's known. It really was established in 1965 by executive order from President Lyndon Baines Johnson following the Civil Rights Act of 1964. So OFCCP's origins are in the civil rights movement in this country, and it was intended as an agency to enhance equal employment opportunity for all Americans in employment. There are three underlying authorities, which can be a statute, it can be an executive order. There are three underlying authorities that OFCCP enforces and that you need to know about. Those are Executive Order 11246, which was the executive order signed by President Johnson. There's Section 503 of the Rehabilitation Act, which is similar to the Americans with Disabilities Act, but for federal contractors. It's a similar law, and it relates to disability, non-discrimination, and affirmative action. And then there's VEVRA, which is a Veterans Protection Statute, Veterans Non-Discrimination and Affirmative Action Statute as well. And in addition to that, there is an executive order that OFCCP enforces on pay transparency. That's important to remember also because that's an additional obligation from the ones that we're going to discuss. So there are 9 OFCCP protected classes. And most of those are in the executive order, but some are also in Section 503 and VEVRA. So the protected classes in the executive order are basically that as a federal contractor, you must take affirmative action and not discriminate based on race, color, sex, sexual orientation, gender identity, national origin, and religion. And in addition to that, under Section 503, you must take affirmative action and not discriminate based on disability. And under VEVRA, you must take affirmative action and not discriminate based on veteran status. So those are the 9 protected classes. And as mentioned, there's also pay transparency, which is another requirement that, and basically what pay transparency is that a contractor can't prevent employees from talking about their pay. Because that's one of the ways that employees can discover if they're being discriminated against based on pay. So if you're a federal contractor, you have a pay transparency obligation as well. Now, there are jurisdictional thresholds which are applicable here. So if you're and those are 10,000, 15,000, 50,000, and 150,000, and 50 or more employees. Well, let me break those down though. So to be a federal contractor subject to OFCCP's jurisdiction, you need to meet the $10,000 federal contract or subcontract threshold. So once you meet that threshold, you are a contractor. That doesn't mean that you are subject to all of the affirmative action obligations of the agency, though. Under the executive order, if you meet that $10,000 threshold, then you need to comply with the executive order, i.e. you need to do general affirmative action and non-discrimination, but you don't have to have an affirmative action program. You have an affirmative action program if you get up to $50,000 contract and you have 50 or more employees. Then not only are you a contractor, but you also are required to follow the executive. You're basically required to have an affirmative action program under the executive order. So that's the EO, the executive order. Next, Section 503. It's $15,000. So to be a federal contractor under Section 503 and to be required to follow, basically affirmative action and non-discrimination on disability status, you need to have a contract of $15,000. Once again, though, you don't have to do an affirmative action program unless your contract is $50,000 and 50 or more employees. So once again, that 50,000, 50 or more employees, that's really the key threshold for having an affirmative action program under the executive order and under Section 503. And then lastly, there's VEVRA. And VEVRA is interesting because there's a different threshold. For VEVRA, to be within the jurisdiction of VEVRA, you have to have a $150,000 contract. And then to have the duty to do an affirmative action program, like the other two, Section 503 and EO and the executive order, for VEVRA, you need a $150,000 contract and 50 or more employees. So 50 or more employees is the same for all three. But it's 50 if you need a $50,000 contract for the executive order and 503, and you need a $150,000 contract for VEVRA. So I know that there's a lot of numbers there, but it's important to know that. And there is actually, if you go on OFCCP's website, there's a really nice graphic they have that tells you these things. And one other practice point you should know is that it's the aggregate of your contracts. So it's not just if you have 7 contracts, all $10,000, then that's really $70,000 contracts. And that means that you're going to meet the $50,000 threshold. And if you have 50 or more employees, that means you have to do affirmative action programs for the executive order and Section 503. And if those contracts add up to $150,000, then you're going to have to do an affirmative action program for VEVRA as well. And one other point to remember is this is federal contractors and subcontractors. So just because you don't directly contract with the federal government, if you're contracting with a federal contractor, and in order to help them perform that federal contract, you're considered a contractor too. And all of these thresholds apply. Now, you may ask, well, how many federal contractors are there in the United States? There's a lot of them. There's about, when I was OFCCP director, we'd often try to estimate how many there were. And the estimates that we used it would vary a little bit, but was approximately 25,000 federal contractors in the United States and approximately 125,000 federal contractor establishments. So what is an establishment? So if you have if you're a company with a headquarters, a couple offices in other parts of the country, and maybe a factory in another part of the country, those are 4 establishments: your headquarters, your 2 offices, and your factory. So there's 125,000 federal contractor establishments about in the United States. And these numbers don't fully include all of the subcontractors that exist in the United States, which can be much, much greater number. It's estimated that about a quarter of the American workforce works for federal contractors subject to OFCCP's jurisdiction. That's a big, again, 25%. That's millions and millions of people. Millions and millions of employees in the American workforce are subject to OFCCP's jurisdiction. And some of the largest companies in the world are subject to OFCCP's jurisdiction because large companies often will have federal contracts. Now, let me make another point there. Just because you're not a large company, if you're a middle-sized or smaller company, you still may be subject to OFCCP regulations because of the jurisdictional thresholds I mentioned. And the agency considers that, and they actually have a guide for small businesses that's available on their website as well. So you may ask, well, what are the affirmative and non-discrimination obligations? Because, particularly if you're thinking about being a federal contractor, you might want to know what you're signing up for. Okay, and we're going to talk about those at greater length in a moment. But just in general, what affirmative action obligations or the affirmative obligations are, that's the duty to do outreach and recruitment and good faith efforts to increase your applicant flow of women and minorities and people with disabilities and veterans in order to match, essentially, what is the availability of those groups in the workforce. So, for example, if you have a job where the availability of women in the workforce based on census data is, let's say, 40%, and your applicant flow is only 20% women and 80% men, then you need to do affirmative action, outreach and recruitment to get a larger applicant flow of women so that it is more like 40%. And the thinking is that if the applicant flow matches availability over time, your workforce will match availability as well if you're not discriminating. One thing that's very important to remember about affirmative action, though, is in employment, when you're talking about affirmative action in employment, that does not mean quotas or preferences based on race or gender. It does not mean that. In fact, those are illegal. Those are unlawful under Title VII and under the executive order and the other authorities I mentioned, because that's considered to be discrimination against a protected class. So that's something you need to keep in mind as well. Affirmative action is not preferences or quotas. Affirmative action is outreach and recruitment to increase applicant flow and to remove barriers to employment of underrepresented groups. Now, what is non-discrimination? Well, it's what it says. And by the way, I want to be clear. Any company that's subject to Title VII of the Civil Rights Act has a non-discrimination obligation. And frankly, that's the right thing to do. You should not be discriminating at all. You should not be discriminating based on a protected class. But putting that aside, it's the law as well. It's unlawful to discriminate based on a protected class. And so it's important to remember that just because you're not a federal contractor, that doesn't mean that you're not subject to a non-discrimination obligation. You're still subject to Title VII. What happens if you're a federal contractor, though, is you also are all of those non-discrimination obligations in Title VII, for example, and in the ADA, they apply to you through the executive order in Section 503 as well. And what that means practically, plus there's a non-discrimination obligation under VEVRA, and there is no similar statute that applies to non-contractors for veterans, except for USERRA, which is another statute outside of OFCCP's jurisdiction we can talk about another time. But you actually, as a contractor, have a non-discrimination obligation as to veterans, which is different than non-contractors. But let's put that aside for a second. When you're talking about the executive order and Section 503, there are already non-discrimination obligations under Title VII and the ADA. What happens if you're a federal contractor, though, is that OFCCP will audit you and will look at those issues systemically across your workforce. They'll look to see if you're discriminating against women in pay across your workforce. And that auditing requirement, auditing obligation, and the duty to collect data so that you can assess whether you have compensation or hiring discrimination or promotion discrimination, that is something that is placed on federal contractors that non-contractors don't have to do. You don't have those record-keeping obligations that can be used in an audit to determine whether you are discriminating or not against your workforce or against a portion of your workforce. And so that non-discrimination obligation is critical too, because when people talk about OFCCP, they're often thinking about those large OFCCP audits, the neutrally scheduled audits. OFCCP does it. It ranges with administrations, but can do 1,000 to 1,500 of those audits of federal contractors every year. And when you see those big OFCCP settlements or large OFCCP lawsuits, that's because of the non-discrimination obligation typically. And that's because of the audit that OFCCP has done to determine if you're following the non-discrimination obligation. And if you're a non-contractor, you're not subject to OFCCP audit. So the only way that would typically come up is if you're sued or if a charge is brought in front of the EEOC by one of your employees or by a commissioner of the EEOC against your company. And typically those EEOC reviews and lawsuits are for individual complaints, not class-based complaints. Although I will say you can have class actions based on Title VII against a non-contractor. And there's a lot of case law relating to that. And the EEOC can convert an individual charge to a class charge in appropriate circumstances where the evidence supports it. But there's a big difference between being a contractor and non-contractor because of your requirement to keep records and the possibility of being audited by OFCCP. And we're going to talk about that more in a bit. Now, one other thing that you should think about, and you know what, let me add one more thing there actually, with the Auditing and Investigation Authority. Because I've talked a little bit about the auditing, which we're going to get into more in a bit, but they also, OFCCP does have investigation authority too. So if you're a federal contractor, your employees can make a complaint to OFCCP that you are discriminating against them, and OFCCP does have the authority to investigate that like the EEOC does. But typically, OFCCP will refer those cases to the EEOC. Most of its time and resources are spent on these large, class-based, systemic audits. And that's why, for most of today, I'm going to be talking about the auditing authority. Now, one other point you should think about before we move on to the more specific parts of this class, the affirmative obligations, non-discrimination obligation, your compliance obligations, is that OFCCP looks like it's going to be doing more and more in this space. Its resources and its budget may be increasing significantly soon. That's important to know because if the agency's budget increases, that means you're more likely to be audited because the agency can hire more compliance officers. The agency can do more audits. So there was a significant increase in President Biden's budget or proposed budget relating to OFCCP to a multiple percentage budget. Can't remember specifically the number, but it was something like from about 108 million to potentially up to increasing by about 30%. So that would be the largest increase in OFCCP's budget in a long time. And if OFCCP ends up having 120 million, 130 or 140 million in resources, you're going to see a really large increase in auditing. In addition to that, the agency is also moving forward, they've said, and they've posted, it says coming soon on their website, but they're moving forward with the Affirmative Action Verification Initiative, which was something that was started when I was OFCCP director. And what that's going to do is require every contractor and establishment to annually verify compliance with AAP obligations. And AAP means Affirmative Action Program obligations. That's a big deal because for many years, OFCCP, as I mentioned, does about 1,000 to 1,500 audits a year. Well, you can do the math. I told you there were 125,000 establishments. That's only about 1%. Or 1.5% of all the establishments in the United States. So OFCCP, one of the frustrations I had when I was OFCCP director, and one of the limitations on the agency is that it's a little bit ad hoc in who it's touching. It's only touching about 1% of contractors. So it's hard to have a really significant impact and hard to ensure that all contractors are being treated similarly and fairly when you're only touching such a small percentage every year. Well, what the Affirmative Action Verification Initiative will do is require, as I mentioned, every contractor every year, like filing a tax return. Everyone files a tax return every year, and then a small percentage of those who file the return are audited. Well, that's basically what's going to happen under Affirmative Action Verification Initiative, most likely, assuming the agency goes forward with it as it has been presented to the Office of Management and Budget. What will happen, or OMB, is that the agency would every year, you would turn in as a contractor basically a certification that you are in compliance for all of your establishments. And the agency may even at some point require you to turn in information with that. And then the agency would evaluate that information and then issue a scheduling list, focusing on the most likely violators, similar to what the IRS does when they audit your taxes. So that will greatly expand OFCCP's reach. And a practice point for contractors is if you don't have affirmative action programs in place, or you've been sort of loose with complying with these obligations I'm about to talk about, very soon you're going to have to every year certify to the agency under oath by a high-level person in your organization that you're in compliance with all these obligations. So if I were you, I would start taking action now to make sure that you'll be able to make that certification. Because you can't make guarantees in this business, and I'm not the director anymore, but as close to a guarantee as possible, if you certify that you're not in compliance, you're very likely to get a show cause notice or an audit from OFCCP. And let me also give a warning: if you certify you are in compliance but you're not, the agency's still going to be auditing companies that certify they're in compliance. That could subject you to potentially criminal sanctions for lying to the federal government or making a misstatement to the federal government, and also potentially the False Claims Act, because you're seeking to get a government contract but you're not telling the truth to the government about a material point, whether you're in compliance with OFCCP obligations. So this is not something to take lightly. And it's very important that contractors are in compliance with their obligations, which I'm about to talk about, and that they're ready to certify. So now let's talk about affirmative obligations. So when you're talking about affirmative obligations, as I mentioned, that's outreach and recruitment, but there's more to that. It also involves record keeping, and really substantial record keeping about every time you list a job, making sure that you're keeping track of everyone who applies for that job, that you're asking for self-identification based on race and gender, as well as disability status and veteran status, that you're using the self-identification forms that OFCCP prescribes, particularly in the disability area, because there's an actual form. In the other areas, there is guidance that you should be following to making sure that you're seeking this information. But you need to do that. You need to do certain postings at your company. There's one of those, for example, is the EEO is the law poster. You need to make sure you post that. There's a number of obligations, and more than 10, I'd say. There's a number of obligations that you need to make sure that you are following. It's not just doing outreach and recruitment. What it is not, though, and this is what I want to make very clear, because there's often misconception about what affirmative action is, and I think it's because of affirmative action in the education area, like for higher education, colleges, college admissions, where under the current Supreme Court test, schools can consider race as a factor among many in making a determination whether to enroll someone for diversity purposes. It could be one factor among many. That is not the case in the employment field. Affirmative action in employment, it is illegal. It is illegal, and this is clear. This is black letter law, as they say. You cannot engage in a quota and say, well, we're going to hire 10% of everyone for this particular job. 10% we're going to hire that will be Hispanic, for example, or 10% will be black applicants, or 10% will be women, or 40% will be women, or whatever it may be. You can't say that. What you can say is, let's look at our current workforce. In this particular area, the availability of black applicants that are qualified for this job in the workforce, according to the census, is, let's say, for example, 20% in this area. 20% of those who would be qualified for this job, according to the census, would be black. And yet, in your workforce, in this job, you're only, in terms of your representation, it's your workforce is only 10% black in this job list, in this job area. Well, that means you have an affirmative action issue. You are underutilized as to black employees. Now, the way to fix that is not to go out and hire a lot of black employees because those employees are black. or those applicants are black. That would be discrimination against all other races and ethnicities. What you need to do, though, is recognize that you're underrepresented as to black employees, and you need to increase your applicant flow by doing more outreach and recruitment. So, for example, if it's something that if it's an area where you need a college degree to apply for this particular position, why not go out and recruit at local historically black colleges and universities, where there tends to be a higher proportion of black students, for example. And you should always look at the statistics. Don't overgeneralize. Take a look. But you need to go and recruit and try to increase your applicant flow of black employees. And that will then, over time, assuming you're not discriminating as well, that will lead to your workforce reflecting the population. And that's true for every group. One thing I often like to say about the executive order, it protects every race and ethnicity, including whites, for example. The executive order doesn't allow you to discriminate in favor or against any of those groups. That's what equal employment opportunity is. So yes, part of affirmative action focuses on women and minorities and also people with disabilities and veterans. But here we're talking specifically about women and minorities, just to illustrate this point that I'm making, that you can't have preferences or quotas. You might have a particular job. One area where there's an underrepresentation of women often is in the construction trades. So you may look and see, we're underrepresented as to women in this construction trade. Let's say welders, for example. That doesn't mean you go out and just hire women welders. That would be a preference. What it means is you got to recruit and figure out, why aren't we getting more applicants who are women welders? And then when they apply, you need to make sure you're increasing the amount of women who are applying. That's your goal. That's what affirmative action is. Then once you actually make the selection, you cannot consider whether that person's a woman or a man. You need to make a blind selection where you're not considering that. But the idea is, over time, if you're not discriminating and you're getting more women applicants, you'll get more women welders. And over time, your workforce will reflect the population. So that's how affirmative action works. A lot of people don't know that. And they think that affirmative action means preferences and quotas. It doesn't mean preferences and quotas. And it's seeking to ensure that women and minorities in particular have a full opportunity to participate in the workforce and receive equal employment opportunity, because those groups historically have been discriminated against and are underrepresented in the workforce in many different jobs. And that's what the purpose of affirmative action is, to correct that over time by increasing the applicant flow of those underrepresented groups. Same thing applies for people with disabilities. This is another group that has historically been discriminated against quite extensively. OFCCP actually has a national goal or utilization rate for individuals with disabilities that is 7%. So and remember, by a lot of estimates, up to 1/5 to 1/4 of all Americans have a disability. A lot of people have disabilities and decide not to disclose them to their workplace, their employer, because they're worried about being discriminated against. So it shouldn't be that hard for companies to meet the 7% utilization goal. But it is a challenge, and this is what I learned as OFCCP director, because a lot of employees will not self-identify as having a disability because of concerns about retaliation. So part of a very good affirmative action program is to have self-identification campaigns for people with disabilities. Use the form that OFCCP mandates. Have a campaign and make sure you include on your website lots of programs to include people with disabilities. Make it clear that you have a disability inclusive workplace, have an accessible website. And what you'll see is and make sure that you grant accommodations, generally as a matter of course, that you don't give people a hard time if they request an accommodation, that you comply with the law, that if for some reason a particular accommodation causes an undue hardship, let me just make a note here, I think it was about 50%, this is the stat we used to use at OFCCP and the Office of Disability Employment Policy, about half of all accommodations have no cost, believe it or not, no cost. And for those that do, the median cost is about $500. that's a drop in the bucket when you're talking about someone's career. So typically, accommodations don't cause undue hardship. But even for those that do, the ideal is to amortize that across your workforce, to have a centralized accommodation system, and to try to accommodate those employees. But if you can't offer an accommodation because of an undue hardship, then offer an alternative accommodation and still try to ensure that that person can work in your workforce. And so that's what affirmative action is for people with disabilities, trying to increase the employment of people with disabilities and increase self-identification to try to meet that 7% goal. And then for veterans, there is a veterans hiring goal, which moves over time. It's for the last few years has been between 4 and 5%. And for that veteran hiring goal, that's what it is. You're supposed to basically hire at that percentage protected veterans. And again, it changes every year, so you need to look at the OFCCP website, but that should be your goal. And that's really what affirmative action is. It's that outreach and recruit. It's a few things. It's understanding your workforce, looking at doing a workforce analysis, determining what is your percentage based on race, gender, disability status, and veteran status. What is the percentage representation in your workforce for women, minorities, disability status, and veteran status? It's looking at what is the availability in the workforce, doing an availability analysis. So you do a workforce analysis, availability analysis. It's then setting goals for how are you going to make your applicant flow reflect what is the availability in the workforce. And then over time, setting these goals and then measuring them and seeing how successful are the goals that we set. That's really the heart of an affirmative action program. And then in addition to that is the record keeping so that you can determine, you can assess your applicant flow and how well you're doing in meeting those goals. There's a number of other technical requirements as well. I won't get into them today, but that is really what an affirmative action program is. Once again, it does not permit preferences or quotas. If there's one thing you take from me today about affirmative action programs, take that, because it's very important that you not engage in preferences or seeking to hire someone because of their race or gender. You can recruit them because you're trying to get a more diverse workforce, but you can't pick them or select them. It's called selection discrimination, or promote them because of their race or gender, because that is a form of discrimination against all other groups that you're not favoring. That is illegal, and that will get you liability, and it's wrong. So make sure that you understand that. In addition to that, what affirmative action is goal setting, good faith efforts, outreach, and recruitment. Includes self-identification opportunity at recruitment and hiring stages and periodically thereafter. We touched on that. Includes annual evaluation of employment practices, including hiring, compensation, and promotions. That's something that's different than most non-contractors do. You need to actually every year do a self-audit, essentially, a self-review to see that you're not discriminating or that you don't have obstacles for people with disabilities, for example. You need to make sure you don't have inaccessible places in your workplace, that you have an accessible website, things like that. But you're doing this annual evaluation that includes pay equity. So you're actually looking at how people are paid. We've talked a lot about selection discrimination, but part of affirmative action is also, including, and ties into the non-discrimination obligation as well, but assessing yourself to make sure you're not paying people differently based on their race or gender, because that's another form of discrimination. The record keeping is key. As I mentioned before, affirmative action verification is coming soon. So if you don't have an affirmative action program in place and they take time to put together, you need to start now, or else you're going to have to certify that you don't have one in place, which means you're going to be likely subject to OFCCP audit. Employers need to get ready. Diversity and inclusion is related to affirmative action, so it's important that you coordinate those. Your DEI initiatives, diversity, equity, and inclusion, and often now I hear accessibility as well. President Biden recently issued an executive order, diversity, equity, inclusion, and accessibility. So DEIA, you should have a program, and you should make sure that they're coordinating with your affirmative action program and your Office of General Counsel. Adopt best practices that enhance inclusion. There's a number of best practices. You can see a lot of them on the OFCCP website. Type in best practices, section 503, best practices, diversity and inclusion, best practices, VEVRA. I worked on a lot of those best practices when I was OFCCP director. Just a few of them, for example, is, let me tell you a few in the disability area, is having a centralized accommodation system, having your CEO put out programming and messaging that's very pro diversity and inclusion, pro disability inclusion. This sort of messaging applies to all of the OFCCP authorities, not just Section 503. But that's, when talking about a Section 503 best practice, that would be one. Having a mental health awareness program and supporting employees in their mental health. There's a variety of having relationships with vocational rehabilitation agencies in your state. That reminds me, for VEVRA, if you have to do affirmative action for VEVRA, you actually have a job listing requirement for your jobs. You have to list them so that veterans will know about them. That's one of the obligations, affirmative action obligations. And it's also a best practice for people with disabilities. Listing those jobs with vocational rehabilitation agencies, for example, or letting them know about them so they can identify for you candidates with disabilities that you can hire. One other thing you should know is, and the agency, this is the agency's position as well, and often talks about this, you're allowed to have disability hiring programs or disability inclusion programs in hiring, such as autism at work programs. A lot of people don't know that. That's actually an area where you can recruit and even favor in selection people with autism or people with disabilities, because this is one area where you can do that, because it's not having a disability is not considered a protected class. So you are actually allowed to, in trying to meet that 7% disability hiring goal, you are actually able to go out and have disability hiring programs. Federal government has one, for example, Schedule A. Federal government can actually avoid doing competitive hiring and go out and hire people with disabilities directly, and your company can as well. But of course, always run that through your general counsel, because you want to make sure that in the areas where you're not allowed to do preferences and quotas, race and gender, for example, and the EO, the executive order protected classes, you want to make sure that you're not discriminating on any ground in those areas or having a preference or quota. But for veterans and for people with disabilities, you are allowed to go out there and recruit and hire, because, as I mentioned, not having a disability or being a non-veteran is not considered a protected class. So those were a few examples of best practices, but there's a lot of best practices in this area. So you should have, and let me give you one more, have a chief diversity officer or a chief accessibility officer, or even better, both, who can help put together your program in this area. And often those officials can coordinate with employee resource groups or affinity groups, where those groups can make sure that those employees that are underrepresented based on race or gender or disability status or veteran status have a group, have supporters within the organization that are raising diversity and inclusion issues. One other point, if you're going to have an employee resource group or an affinity group based on race or gender, make sure it's inclusive, that anyone who wants to be part of that group can be part of the group. So you're not discriminating based on race or gender, but it's perfectly fine to have affinity groups based on race or gender. Women in the workforce groups, for example. I know a lot of law firms have groups for women attorneys. That you can do that, but just make sure that it's inclusive, what you're doing. And certainly for people with disabilities, those are so crucial. You want to build an employee resource group for people with disabilities, because those are the groups that come up with all the ideas on accessibility. And they'll tell you, hey, you have a doorway here that's not accessible, or hey, what's up with the accessible parking spots? There need to be more of them, or it needs to be they need to be cleared out and made more accessible and easy to utilize. It could be for people with non-apparent disabilities, making sure that you have a good mental health awareness program, that you have a good suicide prevention program, for example, for people with depression, that you have resources and supports present. A lot of times it's the disability employee resource group that comes up with all these ideas and leads the change in your organization. So have a chief accessibility officer, have an employee resource group, have diversity and inclusion programs. But let me just say one more thing. Don't cross the line, though, where you're discriminating. So it's great to have diversity training programs where you're talking to people about the history, for example, of racism in this country, or sexism, or ableism, or discrimination against veterans. That's perfectly appropriate. In fact, people should talk about that. We need to know the history of our country, the good part and the bad part. But what you can't do is then target or attack a particular group because of their race or gender. That you can't do. Whatever you're doing in your training programs needs to be inclusive of everyone. That's very important because diversity, equity, and inclusion programs are so critical to the success of our country. We want to make sure everyone can participate in our workforce. That's what equal employment opportunity is. And it's good for this country. It's the strength of this country. It is the strength of this country, our diversity and our inclusion. This is really an area where there is a lot of law. So it's very important that you talk to your general counsel's office, your counsel, that you're making sure you're complying with Title VII principles, because ultimately EO 11246 follows Title VII principles. But as I mentioned before, because of the fact you're a contractor, you're agreeing that OFCCP can audit you when it looks at these Title VII principles. So that's really, it's more of an enforcement / compliance obligation that you're taking on to keep records, to be able to demonstrate that you're not discriminating based on race or gender or any of the other protected classes. So one thing that OFCCP focuses on quite a bit, and this is across administrations, Republican and Democrat, is that the agency focuses on systemic hiring and pay disparities. So it has a hiring enforcement program where it's looking at selection and whether you're favoring certain groups based on race or gender, or steering people based on racial or gender stereotypes or prejudices that may exist. That's one part of OFCCP's enforcement program in the non-discrimination area. And the second is pay equity and making sure people are being paid similarly based on race or gender, and that they're not being discriminated against. Now, before I continue, it's important to note that our country is still struggling with a substantial pay gap that exists. That's about, for women, around 80 cents. So for an average woman will make 80 cents of an average man. And on racial grounds, it's similar. You have similar pay gaps based on race and ethnicity. And for women of color, it's even bigger. There's compound pay gap. There's an intersectional pay gap. For Hispanic women, for example, last time I looked, it was almost 50 cents. It was, I think, 55 cents. What that means is that the average Hispanic woman in the United States makes 55% of what the average white man makes. So think about that. The average Hispanic woman has to work twice as long to earn as much as the average white man. Think of what that means in terms of equal employment opportunity and how far we have still to go. But the other point that's important to remember, and let me also note that for African American women, for Black women, the pay gap is somewhere around 60 cents, so 40%. And check those numbers. They're a little bit different in different studies you see, but it's always the largest for those two groups and also for Native American women. Those three groups have the largest pay gaps. Another group that has really large pay gap, people with disabilities have a very significant pay gap. And when there's an intersection between disability status and race or gender, the pay gap can be even more. So, you have these large pay gaps, but the important thing to remember about pay gaps is that pay gap alone does not necessarily mean that discrimination is occurring. Those pay gaps are in our society. They exist, and that's part of the reason you have affirmative action over time to try to address those pay gaps and to limit them and to hopefully one day eliminate them. That's the goal. But just because there's a pay gap doesn't necessarily mean that that pay gap is caused by discrimination. What's caused by discrimination is what's called a pay disparity. And that's an important distinction because that's what the law is looking at. When they look at your workforce, they're not going to look at what does the average man in your workforce make compared to the average woman. And you may have a pay gap because there's a general pay gap in society. But what they're going to be looking at, the OFCCP, is do similarly situated male employees, are they paid more than similarly situated female employees? That's really the key question. And that's where you have to be extremely careful that the answer is no. There is not a pay disparity. And that's the main point. So how do you make sure you don't have a pay disparity? Because let me tell you, when OFCCP comes in and they audit you, they'll go 2 years back, they'll look at your pay, they actually get the pay for each of your employees. They form what are called pay analysis groups. They group employees together and they run regression analyses to see whether you have a pay disparity. And if you do, they make you fix it. And if you don't fix it, they will actually sue you and seek to take away your federal contracts or get injunctive relief to make you fix it. And if you don't fix it, you'll lose your federal contracts ultimately. Now, it goes through due process. So there's an administrative hearing process. And the agency doesn't always win those lawsuits. So it's possible the contractor will prevail. But if the contractor loses in that case, the contractor is looking at significant potential liability and the potential of losing federal contracts. So this is very serious stuff. You do not want OFCCP to find that you're in violation of the non-discrimination obligation, because that comes with it typically with back pay, which can be significant, and also salary adjustments going forward, which can be expensive. And when you add that all together, you could be talking about a lot of liability. Much better to take proactive action to make sure you don't have pay gaps or pay disparities. That's good for productivity because it means you're paying people the way they should be. So you get the benefit of treating people fairly and being a top performing company in the pay equity area. And there's a lot of evidence out there that those companies are the top most productive companies as well, the ones that treat employees fairly, that have inclusive environments based on race, gender, disability status, veteran status, that they have programs in this area. Those are the top performing companies. But it also prevents you from getting involved in a 10-year audit and lawsuit with OFCCP, which can harm your reputation and lead to really significant liability. So there's both carrots and sticks here. You really need to make sure you're in compliance if you're going to be a federal contractor, particularly as the agency increases its enforcement, increases its budget, starts doing affirmative action verification. Also, employees are becoming more and more savvy, particularly with the pay transparency obligation. They know they're allowed to talk about their pay. So it's very possible they'll find out that there is a gap, and they'll either bring a complaint to OFCCP or the EOC, or possibly bring in class action counsel. So you need to be prepared for all that. And the top companies in this area are doing annual self-audits based on pay equity self-audits to make sure that there's not pay disparities. So what is a pay disparity? I told you I'd tell you what that is. So that's where the company controls for all the reasonable factors that you use to set pay. So you control for them in a regression analysis. And then you assess based on race and gender whether you have a pay disparity. And typically what's used is a regression analysis. And they're looking to see whether, controlling for all the factors that a company uses to set pay, do you have a gap or a disparity between men and women, or between blacks and whites, or between Hispanics and whites, or Hispanics and blacks? It could be any race or ethnicity. Do you have a gap that's 2 standard deviations? And do you have a gap that's at least, typically the agency right now under its current guidance is looking for practical significance too of about 1%. So do you have a pay gap of at least 1% to 2 standard deviations? And if so, the agency is, and particularly if it's over 2%, the agency is likely, according to its guidance, to make you fix it. And even if it's less than that, if it's a % pay gap, but it's 2 standard deviations, they're likely to make you fix it as well, particularly Democratic administrations tend to be more focused on enforcement, and Republican administrations tend to be more focused on compliance assistance and settlements. So if in the Biden administration, President Biden has made it a point to say that he's going to be focusing on discrimination in employment and pay equity in particular. And so has Director Jenny Yang from OFCCP, and so has EEOC Chair Charlotte Burrows from the EEOC. They've all said pay equity is a top priority. So you should assume that any pay gap to 2 standard deviations, the agency will likely make you fix. So now, what are the factors that are used, the legitimate factors you can consider in determining whether there's a pay gap? Well, one of them, for example, is typically tenure. As people work at a company for longer, they get paid more. You get a raise every year if you have good performance. That's another factor that's typically looked at. Evaluations and performance. Well, make sure that if you're going to look at evaluations and performance and say that that's a factor you use in setting pay, make sure you keep those records and make sure you're evaluating them every year that you don't have a particular supervisor who tends to favor men over women or tends to favor white employees over black employees in evaluations. You want to look at these things systemically. That's why these yearly reviews are so important. But that's typically another legitimate factor is evaluations. So tenure, evaluations. Another one is education. So if it's a job where having an advanced degree is helpful, some people are paid more based on that. That's a legitimate factor. Another factor could be productivity. So if it's a position like in sales and you have someone that brings in more revenue or works more hours, that's another legitimate factor. That's how people are paid. And OFCCP should not be substituting its judgment for how you set your pay. As long as they're legitimate, non-discriminatory factors, you should be able to set your pay however you wish. This is a market economy, after all. And that's what makes America such a engine of progress and productivity is its market economy. But it's always also very clear that you cannot have a factor where you consider race or gender. And I said that before with selection. It's true with pay as well. You cannot pay someone more based on their race or gender. And if that is determined to be a factor you're using to 2 standard deviations, the agency will find you in violation and make you fix it. So how do you prevent that? Do an annual self-audit. Look at pay equity, form pay analysis groups. What's a pay analysis group? That it's in the field among management attorneys, for example, like myself, we typically will say similarly situated employee groups because we're focusing on the fact that you really under the law you need to be comparing similarly situated employees. Yeah, 2, it's very true. Equal pay for equal work. That's the Equal Pay Act. And even under Title VII, a woman who's doing the same job as a man or a similar job, pretty similar, they should be getting paid the same. That's the idea. Otherwise, you shouldn't be paying men more than women or women more than men. It goes both ways. More often, it's paying men more than women, but sometimes the agency will find that the agency is discriminating against men. It happens. It happens on race and ethnicity too. You see discrimination going both ways. You see it you typically see it against minorities. Sometimes you see it against whites. Agency, equal opportunity. If they find a disparity based on race or gender, no matter who's the favored group or disfavored group, agency will make you fix it. But they will, in making that determination, they will group all the employees that are similarly situated. Now, I'll tell you, the agency takes a broader view of what is similarly situated than most employment attorneys. And that's an ongoing debate between the agency and employment attorneys. And now I've been on both sides. I've been the OFCCP director. I'm an employment attorney, management side employment attorney now. So I'll be part of that debate too. And you see that in these audits. That's often the back and forth. But the point is that you want to avoid a finding by OFCCP. So you want to try to mimic, to the extent you can, an audit that they would do. So the goal is, for example, if you have 4 levels of engineers, an engineer 1, an engineer 2, an engineer 3, and an engineer 4, agency is likely to group all those engineers together. And you might say, well, wait, an engineer 4, they have a lot more experience than an engineer 1, and there's additional education requirements. You need a PhD in a particular area to be an engineer 4, or whatever it may be. Yes, those are legitimate differences, but in the end, they're all engineers. And what the agency will probably do is group them all together and then control for their education, for their tenure. So they'll say, no, we're not gonna disregard the fact that some of your engineers, to be an engineer 4, you need to have more education and training and more tenure, but we're going to control for that. And we're then going to see whether, when we group these 4 job titles or job groups together, and we have like 100 employees in these groups, we're going to see if you're paying men and women differently when you're controlling for the legitimate factors. And if they find it, they're going to make you fix it. And the reason they often do that is because the agency is concerned that some employers will steer men into higher paying positions, engineer 3 and 4, and women into lower paying positions, engineer 1 and 2, and that it may not be based on legitimate factors. So they want to look at all of that, and they'll typically group them together. So that's something that you should, again, talk to counsel about. Forming those pay analysis groups is important. The idea, though, ultimately is to make sure that you, as a systemic matter, are not paying people differently based on race or gender. And now, as a best practice, although the agency doesn't typically look at disability status or veteran status that way, you can't, let me be clear, you can't discriminate based on pay, based on disability or veteran status, but the agency's systemic audits don't currently require companies to produce the information that would allow them to look systemically at disability pay discrimination or veteran pay discrimination. But as a best practice, and recognizing that the agency may go there eventually, we almost went there when I was director. And in a Democratic administration, there's a good chance that at some point they're going to be trying to do that. I actually proposed that companies be required to produce information to OFCCP so that it can be evaluated based on disability status and veteran status, so that pay can be evaluated. It ultimately was not approved by the Office of Management and Budget, but because they viewed it as a regulatory burden. But there is a reasonable chance that a Democratic administration may do this, or a future Republican administration. So it's important as a best practice that you're looking at pay disparities based on disability status and veteran status as well, because those are 2 other areas where people will self-identify, so you can actually look at their pay systemically. Now, if you're really going to do it the right way and you have a large enough workforce, you should be using regression analysis. You should actually be controlling, just like OFCCP does, forming pay analysis groups, controlling for legitimate factors that the company has records for that they use to set pay, the factors used to set pay, and then determining whether there are pay disparities. Once you identify a pay disparity, you should seek to eliminate it. And that's through pay adjustments. You should talk to a counsel about how to do those in a way that is fair and appropriate and consistent with Title VII principles. Let me give you one point here. And it's similar to the one I made about affirmative action. You cannot pay people differently or give someone a raise solely because of their race or gender, or frankly, because of their race or gender. You can't do that. That's a form of discrimination. So for example, if you don't do a regression analysis and you just run a general average, okay, let me look at all my engineers. The male engineers get paid 10% more than the female engineers. But you're not controlling for tenure. You're not controlling for all the reasonable factors used to set pay. And you just say, you know what? We're going to give all female engineers a 10% raise because they're women and we have a pay gap. That is a form of discrimination and could lead to the agency finding you in violation for discriminating against men, and could lead to a class action by male employees. So you got to be very careful. You can't do that. What you can do is you can run a pay equity audit. You can determine that you have a pay disparity against this group of women in this job area because, and that cannot be explained based on legitimate factors. Then you have a class of women that you have determined have a pay disparity. Then you can go in and fix it because you're making sure that you're paying them equally. That's a best practice. In fact, that's legally required. That's what you should be doing. You should be making sure that there's not pay disparities. But you're paying them not because they're a woman or a man. You're paying them because they are being underpaid and they're in a protected class. That's why you're making the adjustment. That is permissible. So, just keep that in mind. That's why it's so important to do these pay equity audits, to bring someone in to do the audit the correct way, and to consult your legal counsel. So let me just briefly talk to you a little bit about the audit and litigation process. So what happens is OFCCP every year, sometimes twice a year, will publish a list of all the establishments and corporate headquarters it's going to audit. And this is done based on a neutral scheduling methodology that the agency posts on its website. And typically what the agency is looking at are larger establishments by district, and there's 48 district and area offices, 6 regional offices. They're looking by district and region. They're taking the largest establishments that haven't been reviewed in the last 2 years or don't have a present audit. And those are the ones that are coming to the top of the list and typically get listed. In recent years, the agency has also been adding other factors, such as whether the company has prior violations, like in the OSHA, workplace safety, or wage and hour areas. And a couple methodologies ago, the agency looked at certain sectors of the economy where the agency had found a higher violation rate in the past, and took 3 industries, for example, that had the highest violation rate. So agency is going to continue publishing its methodology. It's continued to do so. It started during the Trump administration, but it's been continued in the Biden administration. So I think it's very likely that the agency is going to continue publishing its methodology, continue publishing its scheduling list that also started in the last administration and it's continuing in this one. I actually published a directive, the Transparency Directive, that commits the agency to transparency, to publishing more information, more data, sharing more information with contractors, including the scheduling methodology and scheduling lists, for example. So that's something that's likely to continue. If you're on that list, you typically have 45 days before the agency could list you. You might have more than 45 days, but you have at least 45 days. And then once you're listed, you receive a scheduling letter. You get 30 days to produce to the agency all of the records that it's seeking from you to be able to run all of these tests that I just talked about. And then you got to produce that to the agency. And then at that point, the agency will do a desk audit, it's called. The agency's tried to decrease the length of that desk audit. If the agency finds problems, they'll let you know. They may at that point, they may go on site and interview people. They then may issue what's called a preliminary determination. And we issued a rulemaking when I was director requiring the agency to issue these preliminary determinations whenever it's going to find discrimination or potential discrimination occurring. You have an opportunity to get the data that the agency is relying on to make this finding. At that point, you have the right to make a response. These are all things that were added in this regulatory framework that I did when I was director. At that point, if you do see that there's a violation and you've responded to it, you go into conciliation with the agency. Potentially, you can do, it's called early conciliation before a notice of violation. So we talked about the early resolution process and the preliminary determination. Once the agency decides to issue a notice of violation, that's when you enter the formal conciliation period. The agency has to go back and forth with you to try to resolve the violations. This is similar to what happens with the EEOC under Title VII. They have a conciliation obligation as well. In my opinion, it's a little more robust in the OFCCP area because when I was director, we indicated that we would, share more information with the company that's under audit. This is part of the regulations that the agency has about sharing information, trying to work the matter out. It could be an early resolution or it could be a later conciliation agreement. At that point, if the conciliation agreement is not reached, the agency has the decision whether to refer the matter to the solicitor of labor to bring a lawsuit in front of an administrative law judge or refer it to the Department of Justice to bring it in federal court. Typically, the agency refers it to the solicitor of labor, who then evaluates it and then makes a decision whether they are going to file a lawsuit. One thing I added when I was OFCCP director, which I'm hopeful the current administration will continue, was a mediation step, pre-referral mediation, after the conciliation process, but before the referral process, right before, where the agency has made a determination to refer it to the solicitor, but there's one final chance where both the regional office for OFCCP and the national office meet with the contractor and their counsel and try to resolve the matter. With a mediator, can be a federal mediator in the Federal Mediation and Conciliation Service, or it can be a hired mediator that's like a private mediator. And the parties work that out according to the directive I issued. And then at that point, if the case settles, there'd be a conciliation agreement. If not, it's referred to the solicitor of labor. And then the solicitor will bring a case in front of an administrative law judge. And as I mentioned before, they'll typically sue for injunctive relief to make the company correct the disparity, both in back pay, fixing it going backwards, and also fixing it going forward through salary adjustments. And the agency views that as equitable relief. It's an injunction. The court would order you to do that. And then in addition to that, the agency basically requests that if the company refuses to do that, that they be debarred, which essentially means they lose their federal contracts. And the agency can also request that any current contracts be canceled, which is a huge remedy potentially. So federal contractors need to be careful about that. You don't want to lose your federal contracts. And of course, in the end, contractors have a right. This is why we issued these regulations when I was director. They have a right to present their evidence and argue that they are not discriminating. And if they're found to be discriminating, they have a right to also contest damages and to argue, well, the agency has misvalued the amount of damages. And typically, these cases will involve experts on both sides. They'll typically be quite expensive cases to prosecute and to defend, which is why they often settle. Because there's a degree of uncertainty. It also is a really long process. The ALJ process can take, first of all, the audit process can take several years. When I started as OFCCP director, we had over 100 cases, and I've said this publicly, over 100 cases that were 4 years old at the audit stage. We had one case that settled right when I started the agency that was 23 years old, that had gone through litigation back and forth. Just think about that, a 23-year-old audit. And litigation. Think about a 4-year-old audit. And let's say, for example, the company ends up being found not to be in discrimination. Well, having to go through a 4-year audit with the federal government is a form of punishment in itself. So, companies want to show they're in compliance, but they don't want the federal government in their business for years, which is one reason why these cases settle. And one reason why it's important to do all of these obligations in advance so you can get a closure letter in 45 days. That's much better. But obviously, if you end up having a finding and you contest the finding and it goes to the ALJ process, at that point it goes to the Administrative Review Board of the Department of Labor, which is another administrative body. Then, under the current rules, the Secretary of Labor gets to take a look at it as well, if the Secretary wishes. And then it goes through the federal courts, through the APA process. It can go all the way up to the Supreme Court, District, Circuit, Supreme Court. That's why these cases can take a decade or more to resolve. From the opening scheduling letter to the end of the resolution, it could be millions and millions of dollars in fees, legal fees, and of course the remedies can also be millions of dollars as well. So this is something that you got to take seriously. Don't take it lightly, and make sure that you're in compliance. Pay equity is a huge issue, and it's only going to become a bigger and bigger issue in the upcoming years. And that's true no matter who's president, no matter whether it's a Republican or Democratic administration. Let me tell you one other thing. There's the agency, when I was director, had the 2 years that I was director had the two largest years in terms of recoveries in its history. And in fact, the 4 years in the Trump administration, the recoveries exceeded the prior 9 years combined. And, the reason why is in part because of compensation discrimination and the focus on pay equity, and also a focus on trying to settle cases with companies sooner. But, there have been a lot, the agency makes a lot of findings every year, and this is both in Republican and Democratic administrations. So this is not something that's political. A lot of times people think that, but it's not. This is something that all administrations care about. OFCCP is getting a lot of attention. And, they did have a couple recent cases. One of the big ones was the OFCCP v. Oracle case, where the agency lost a pay discrimination case, where the agency in its complaint alleged over $400 million in pay disparities. And Oracle strongly contested it, and it was a very contested hearing. And ultimately, the administrative law judge found that OFCCP did not produce evidence showing discriminatory intent. And so Oracle won the case. But just think about the size of that case. And let me tell you, when I was OFCCP director, we had a lot of cases with very significant disparities, at least from OFCCP's perspective, where you're talking about tens of millions of dollars in potential liability, even sometimes hundreds of millions of dollars in liability, depending on how you look at it, like in the Oracle case, for example. And so, when I was director, we decided not to appeal the Oracle case because we felt the findings by the administrative law judge would be difficult to overcome, and also because the agency had changed the way that it assesses pay in these regulations that we issued. So, that was a determination I made as director. But Director Yang has come out and said that she doesn't agree with the decision in Oracle, the administrative law judge decision. And there's a reasonable chance that the agency will continue bringing very, very large cases like that. And those cases take years. And you're talking about substantial liability. So what's important is that you take this extremely seriously. And not only because it's the right thing to do to eliminate pay disparities, but also there's significant potential liability. Let me talk a little bit about how artificial intelligence can help you achieve that. And I'm going to refer to it as AI when I talk about it. So AI allows the company, the contractor, your company, to clearly set hiring factors to be considered, minimum and preferred qualifications, which allows for a more objective hiring process consistent with company objectives. You can even go so far, and this is why it's so ideal in this space, to remove any indicators of a protected class, which means that you can make selections without regard to unconscious bias. So that's a huge area where artificial intelligence can help you. It can allow the human factor, the human being, the hiring officials, the HR personnel to set, well, what are you looking at when you consider who to hire? What are the important points? What are the needs? And AI can take all that information, show you the employees that meet your minimum and preferred qualifications that are excellent matches for this particular job, and then eliminate any indicator of a protected class, which then allows you to pick, though, you could select someone based on that. You could pick who you're going to interview based on that. But that ability to do that is very helpful. And that's key in terms of complying with non-discrimination obligation, in my view. The elimination of unconscious bias. That's going to help companies a lot. In addition to that, AI helps, in addition to the blind grading, and the removal of potential knowledge of race, gender, disability status, protected veteran status, for example, as well as other protected class bases, it allows you to prioritize the merit factors. So that's the whole key to equal employment opportunity. Eliminating the protected factors, you can't consider those, and prioritizing the merit-based factors, so you're picking the best person for the job every time. And assuming you're doing your affirmative action as well, what that means is over time, systemically, your workforce will represent the population. That you won't have underrepresented groups because you will be advancing people, you'll be having a better applicant flow, and then when you actually select people, you'll be selecting based on merit and merit alone. That's the best way to have equal employment opportunity and build a diverse workforce. You can assess whether you are having adverse impact, and you can correct it in the algorithm or with the factor, and it can tell you which factors or what stage in the hiring process is causing the adverse impact. So it's really helpful for diversity, affirmative action, and non-discrimination efforts, because you can eliminate the obstacles to equal employment opportunity very easily because you're using a platform that is taking all this information in and can assess it in real time. So that's a really key factor. So in addition to allowing, eliminating unconscious bias and allowing for blind grading, it still lets you, which essentially eliminates disparate treatment, or can eliminate disparate treatment, because you can have blind grading and not consider protected classes. They can take that possibility away. which addresses disparate treatment. But in addition to that, it addresses disparate impact by allowing you to assess in real time what the adverse impact is, why is it being caused, is it for something that is validatable, can it be validated, is it a particular factor that is needed for the job. So for example, let's say you have a 100-pound lifting requirement. 100-pound lifting requirements typically cause a disparate impact against people with disabilities and women. And let's say that's what's causing you to have the adverse impact when you're assessing in real time the people you're hiring for this particular job. Well, the AI will tell you that, and then you can decide, well, do we really need a 100-pound lifting requirement? What about a 50-pound lifting requirement? What about a 20-pound lifting requirement? And that's going to increase the applicant flow for women and people with disabilities, people that can meet the minimum qualifications for that job. So that's something where AI is way ahead of what a lot of companies have been doing in the past, because you're able to assess that accurately in real time. So that's a big point. Likewise, artificial intelligence helps with record keeping, obviously, because you're having a platform that's keeping all this information, which is going to be helpful for you if you're audited, because you can demonstrate what factors you're actually using to hire someone. And that's really what the agency wants. And a lot of times you find the agency being frustrated or finding a violation because the company says that they used a particular factor in hiring, but they can't prove it through records. So the agency will typically not consider that factor because you don't have records showing that that was a factor that you used. Well, AI helps with that as well. Likewise, in the diversity and affirmative action area, AI can facilitate evaluating applicant flow, again in real time, to determine if outreach and recruitment efforts are working. And they can tell you in real time, again, and certainly daily, weekly, however often you want, whether you're having an underrepresentation in your applicant flow, people applying for your jobs based on race or gender. That's where affirmative action comes in. It can help guide your affirmative action to do more outreach and recruiting. It can also help match diverse candidates with your company, because that's what AI does. It will look at candidates and say, oh, wow, you know what? We're not even considering this group of candidates over here, this group of candidates with disabilities, for example. Why don't we consider them as well? They have the skills necessary for this job. So through that sort of outreach and recruitment to groups that are underrepresented, who have the skills, employees who have the skills, but they're part of underrepresented groups in your workforce, you can use AI to identify them and to recruit them. Now, of course, once you get to the selection phase, you can't consider race or gender. You can use the affirmative action components of AI to enhance your outreach and recruitment. And then you can use the non-discrimination aspects of AI to ensure that you're eliminating unconscious bias or selection discrimination. So these are real positives of AI for companies. Lastly, AI also allows you to demonstrate exactly what factors are considered at every phase. I know I touched on that a little bit earlier, but I can't emphasize enough how important that is for OFCCP. They want to know what you're doing, and they want to make sure that it's not discriminating based on a protected class. So having a platform that keeps this information ensures that you're considering diversity factors at the appropriate stage, which is recruiting and outreach, and that you're not considering those factors at the appropriate stage, which is selection, promotion, pay. That is key to an OFCCP compliant program. And that's why this is so helpful, artificial intelligence. In my view, 10 years from now, 20 years from now, artificial intelligence will likely be the standard of care in this area. You'll see lots of companies using it in the way that I just mentioned, because it'll be so helpful in increasing the diversity of their applicant flow, and it will be so critical in ensuring non-discrimination, both disparate treatment, that's not occurring, and disparate impact, that's not occurring. That's why artificial intelligence can be so helpful to companies and their EEO programs. We've all heard how helpful it is in terms of productivity and matching the right candidate with the right job, but don't underestimate how helpful it can be in having an EEO program, having an OFCCP compliant program, following all the best practices that OFCCP would like companies to follow. what are the final points to take from my class today? First, OFCCP's reach is going to continue to increase over the course of the next several years. I think I've made that clear in a number of ways. Their budget, the messaging coming from the agency, the fact that recoveries have increased in a Republican administration, and you're likely to continue to see enforcement and settlements in a Democratic administration. This is not dependent on which party is in power. This is something that's going to continue to be a focus of the federal government, and it should be. It should be a focus. Look what's happened over the past couple years, how important we've seen that racial equity, that gender equity, social equity, disability equity, equity in every protected class, equity in every area, how important that is. Companies want to respond to what's happening in our country, to the protests over the past year. Companies want to show that they get it. Well, if you're a federal contractor, the way you can show that you get it is by having compliant affirmative action and non-discrimination requirements. One thing I used to say all the time as OFCCP director to my wonderful colleagues at the agency, and it is a wonderful agency, in my opinion, what I would often tell them is how lucky you are to be in this field, to be able to do something about discrimination and inequity. And as federal contractors, as HR professionals, as stakeholders in this field, you have that same opportunity to be at the lead in diversity, equity, inclusion, and accessibility, making sure that all parts of our American population, all of us, can be part of the American dream, be part of the American workforce, be part of the great American experiment. That's what makes our country so wonderful. You know, the ability, equal employment opportunity, the ability to advance and, see what you can do without regard to race or gender or any of the protected classes. Being given a full opportunity to be yourself, to bring your whole self to work and be successful. And that's why artificial intelligence, as I mentioned, is so critical. That's why equal employment opportunity is so critical. And companies, by being in this class, by watching this class, it's clear you want to do the right thing and you want to be compliant, and it can be done. I won't go so far to say it's easy. I mean, there are a lot of obligations and you got to be careful, and you need to bring in counsel, and you need to make sure that you have a comprehensive program, but it can be done. It can be readily done. And a lot of contractors do it each year, and they deserve a lot of praise for that. And in fact, a lot of contractors go beyond the requirements of law, which is really what deserves the praise, with best practices and seeking to build seeking to build opportunities that are equitable and provided to all, that your whole workforce can be part of what you're trying to do at your company. That's really the key. So contractors need to be proactive, and they should use the best technology to help ensure compliance and that bias is removed from hiring. And if you do that and you follow the tips that I've talked about today, and you build an OFCCP compliant program, you know what? Not only are you going to comply with the law, it's going to help your productivity. It's good for business as well. And that's the secret. Inclusion, diversity, making sure that you're hiring based on merit, all of that is part of a good business model and good business. So it's not just about making sure that you're complying with the law, although make sure you're complying with the law. It's also about doing what's best for business. These best practices every company should adopt, not just federal contractors. So thank you again for being in the class today. I've enjoyed it very much. It was an honor of a lifetime to be OFCCP director, and I'm enjoying being a management side attorney and advising companies on compliance with OFCCP regulations and best practices as well. Have a great day.